questions coming in, and I know we've covered a lot of this, but if each of you could maybe give your thoughts. And Larry, we're going to start with you, and then Russ. How do you select which patents to assert in a litigation?
Great question. I like to assert patents that in some way maximize the chances of at least one being infringed, and that ends up being valid. So, oftentimes when you look at claim language, you'll identify some potential weaknesses in the case. Maybe there's a claim term, depending on which way it's construed, could go one way or another. So I like to think about orthogonality of success. Pick a group of patents where you don't have common weaknesses among the group. That there are, try to maximize the number of independent ways that you can win. That's I think that's the short of it.
Yeah, I would just add to that. I think that when we're looking for patents to assert in a campaign, it'd be great if you can assert patents that are in different families, right? Not just, so you may have 5 patents and they're all continuations of each other, right? So they're in the same family. Those claims may not differ very much, right? So in Larry's example, like if the same prior art could invalidate all of them or be very closely, that's a bad choice, right? So try to, if you can pick where you've got either continuations apart or even different families that you can assert in multiple patents, that's a much stronger campaign to sort of, so that a licensee or a defendant understands that you're not just going to go away. You have a lot of patents you can assert that cover a lot of different things. It helps you avoid the validity challenges.
Excellent. I want to get to this quick question here. I know we are limited on time. If we could, Russ, I'm going to start with you, and then if you could, Larry, give your thoughts. But attendee wanting to know, is the material shared with a funder protected from disclosure in litigation?
That is an excellent question. And the answer to that is yes, with one caveat that if you work with any reputable funder out there, the first thing that we will ask for you to do is to sign a non-disclosure agreement, an NDA. People oftentimes misunderstand the purpose of that. It's not really to keep everything confidential. It's to show that you intend, because the material you're going to provide to me, a lot of it's going to end up getting disclosed anyways in your infringement contentions. I'm going to ask for claim charts, right? But the point of the NDA is to follow the case law, and it's the Miller versus Caterpillar case from the Northern District of Illinois that pretty much everybody follows. That says so long as the parties have a non-disclosure agreement in place before they send material to a funder, that material remains protected under the attorney work product doctrine. Okay, because that shows that you did not intend that material to be widely disseminated in any way, and it's protected under attorney work product, not attorney-client privilege. Some courts will find that the material you send to a funder is protected by attorney-client privilege under the common interest doctrine, but that's kind of like the exception, not the rule, because it's hard to say that you're providing stuff purely for a legal purpose and it's not for a business purpose, which is what you need under common interest. But it is protected under work product. So I can tell you, we catch subpoenas from now and again. You cite the case law, and we've had courts from California to the East Coast to the ITC saying, nope, it's all protected by work product. So just get your NDA in place and you should be good.
Larry?
I think that was well said, Russ. I have nothing to add to that.
Excellent. Gentlemen, thank you so much. A wonderful webcast. Unfortunately, that is all of the time